the letter. I did exactly what was asked in that cease and desist, even though I didn't have to. I technically didn't have to, but I still did.
I've got it up on screen. It says, Dear
Okay.
Ken Jennings, I represent Kelly Long. I understand you are in possession of a petition for writ of mandamus filed recently by Michael Long. And at the time, you were not in possession of this, right?
Yeah, I didn't have that document. And so that was like, I didn't have that document, and it wasn't my plan to go over that document. I was trying to start with the early stuff and then make my way back to the, try and get closer to the newer stuff. But
In the custody disputes with his ex-wife Kelly, the petition is not part of the public record and is subject to a court sealing order. Actually, the petition for writ of mandamus is not subject to a court sealing order that I've seen, because the petition. So this is something. Let's get into a little bit of legal trickery going on here. The petition for the writ of mandamus is filed in the Fifth Court of Appeals in Texas, if I'm not mistaken. It is filed in the Fifth Court of Appeals in Texas. And in that, while that petition is not quote unquote publicly available, there is no sealing order from the Court of Appeals that is suppressing that petition for writ of mandamus. There is not one. If there were, so this lawyer has actually misrepresented to you the law. This lawyer lied to you in a cease and desist, which may be a violation of this lawyer's ethical responsibilities, if we're being honest here. But we're lawyers, so who cares about honesty? But
yeah, what's that?
The petition for the writ of mandamus is a separate case filed in a separate action in an appeals court, and under Texas rules of civil procedure, if there is an order sealing something, that order is to remain publicly available. I checked personally the Fifth Circuit, or the Fifth Court of Appeals in Texas, not the Fifth Circuit, that's separate, that's the federal court, Fifth Court of Appeals. I checked this case, which is publicly available. The case is, the writ is not, the petition for the writ is not publicly available. However, there is no order sealing that writ petition in this case. And there must be, under the rules of Texas civil procedure, there would be an order for it, and that order would be public, because people need to know if there's a sealing order in the case. It's almost like you can't be bound by an order that you literally cannot find. So that's a misrepresentation.
They may have cast a cloak. They may have thrown a cloak of invisibility over it or something. That's probably why we don't see it.
I'm being very, very kind to this lawyer by saying it's a misrepresentation, by the way. She knows exactly what she did.
You want to add an extra dimension to this? I got an email from someone saying that they received a similar letter, a similar email, and that I haven't been able to verify, I haven't had the time, but that they got a similar email, but there were some things missing that weren't the same. From the same lawyer, but that this person isn't actually representing Kelly. So I don't know if that's the case. So I don't know if this lawyer's actually on retainer or anything for Kelly, and is a separate lawyer who would be sending it. I don't
know. They might not be the lawyer in the case, but they could still be representing her. So
like a family lawyer. I don't know.
Like a family law lawyer may be representing Kelly, and then Kelly may have hired separate counsel to manage PR and things like this, for example.
Yeah, so I figured something like that, but
yeah,
it's possible or something like that. I just thought it was interesting that someone emailed me about that.
Yeah.